Hello, and welcome back to Constitutional Fraud. I'm your host, William Toppi. In today's exploration, we embark on a revelation that transcends my personal journey and speaks to the heart of the very fabric of our nation. As I petition the United States Supreme Court for a writ of certiorari, I've come face to face with the stark truth about our Constitution. It's not a universal shield at all, but rather a selectively wielded tool. I've discovered the promise of justice for all is often contingent on who interprets it. The United States Constitution, our supposed beacon of equal rights, is, in reality, a myth. This realization goes beyond my case. It unveils a broader narrative of two Americas. One, a realm of absolute privilege where the wielders of legal power reside, and the other, a world where the rest of us navigate the maze of justice, often measured by factors beyond our control, like race and social class, while education stands powerless in the face of such disparity. Today we unravel not just a personal quest for justice, but a revelation that touches every citizen, challenging the very essence of what of the people, by the people, really entails. Join me as we confront the myth and reality of constitutional rights in America. The United States Supreme Court, as the highest court in the land, serves a critical role in interpreting the Constitution and federal laws. Its primary function is to review and rule on cases that have profound legal implications, often addressing constitutional questions. A writ of certiorari is a formal request asking the court to review a lower court's decision. However, it's not an automatic process. The court selects cases it finds of national importance or those presenting unsettled legal questions. In my journey through the Massachusetts justice system, I encountered undeniable evidence of fraud perpetrated by my specially appointed counsel, Deborah DeWitt, and the sentencing judge, David Ricciardone. Faced with this injustice and a system that seemed to ignore not only its own state laws, but federal laws as well, I turned to the highest judicial authority in the country. I filed a petition for a writ of certiorari with the United States Supreme Court, urging them to examine the fundamental issues at play in my case, hoping for a fair and just resolution that transcends the fraud I encountered in the Massachusetts judiciary. This episode explores not only my quest for justice, but also the broader implications for the constitutional rights that we are all told from birth are guaranteed to every citizen. Now, a word from our sponsor. This episode of Constitutional Fraud is brought to you by Supreme Court Rule 10, Considerations Governing Review on Writ of Certiorari, which states, a petition for a writ of certiorari will be granted only for compelling reasons. A U.S. Court of Appeals has entered a decision in conflict with the decision of another U.S. Court of Appeals on the same important matter, has decided an important federal question in a way that conflicts with a decision by a state court of last resort, or, like my case, has so far departed from the accepted and unusual course of judicial proceedings or sanctioned such a departure by a lower court as to call for an exercise of this court's supervisory power. Now back to our episode. Let's take a look at what I presented to the United States Supreme Court. I filed this petition with the United States Supreme Court. It was 6 months out of time, which meant I had to file a motion just to get them to accept it, which is unusual in itself, but they did accept it for filing. I'm not going to go over everything. I'm just going to go over my question about the Massachusetts justice system. My question was whether Massachusetts Appeals Court Rule 23 is unconstitutional. The First Amendment grants to the people the right to petition for redress of grievances. This right guarantees that the petitioner will not be punished for doing so. Rule 23 undermines the reviewing process. Summary decisions are primarily directed to the parties. They are not circulated to the entire court and may not fully address the facts of the case or the panel's decisional rationale. Decisions from the appeals court should merit the panel's full decisional rationale to fully comply with the law. Rule 23 may be cited for persuasive value, but not as binding precedent. However, Rule 23 is binding to the individual who is faced with this type of decisional rationale. It is not binding to the people, meriting only a persuasive value. This disparity on an individual's rights is unconstitutional. Judges' legal conclusions are to provide insight into their analysis, both for the parties to understand and formally, so an appellate court can examine the trial court's reasoning on appeal. Judges are obliged to cite precedent upon which they rely, not on what they find persuasive. Effectuating Rule 23 obscures the appeal panel's full thinking and thus undermines the reviewing process itself. In this case, in its decision not to review the defendant's appeal, the panel employed summary judgment Rule 23. This rule dictates that either there was no substantial question of law presented or there was a clear error of law. In its decision, the appellate court panel affirmed that the defendant claimed the plea judge accepted his plea in violation of his federal and state constitutional rights. The defendant argued in his brief that the plea judge falsely asserted to the defendant that he was persuaded to follow the guidelines. The plea judge then lobbied the terms of probation with the defendant in open court, asserting that the defendant would face a 10-year sentence if he were to violate probation for breaking and entering. The defendant argued on appeal that under the Massachusetts sentencing guidelines, that type of disparity in the sentencing structure is not allowed. This false assertion made by the judge in eliciting the waiver of constitutional rights was a clear violation of the canons of judicial conduct, Rule 1, upholding the integrity of the court, and 1.1, compliance with the law. In a factual context, employing Rule 23 principles, either the judge violated the rules in the law or he didn't. However, without a full review of the defendant's arguments, Rule 23 may not fully address the facts of the case or the panel's decisional rationale. This rule opens the door to discretionary abuse, which is readily apparent in this case. The panel further affirmed that the defendant argued that, among other things, plea counsel perpetrated a fraud upon the court. The defendant argued in his brief that counsel used an in-court identification to place her client at the crime scene committing a crime. Counsel stated that a neighbor identified my client from a Facebook photo that the police didn't see. The defendant provided a motion to suppress with his brief that counsel filed on behalf of her client. With that brief was a sworn affidavit from counsel stating, during the investigation, the investigating officer assessed the defendant's Facebook page and showed a picture from the Facebook page of the defendant standing next to his vehicle. Again, employing the either-or standard of Rule 23. Either counsel committed perjury when she improperly referenced her own suppressed evidence, or she didn't. However, without a full review of the defendant's arguments, Rule 23 may not fully address the facts of the case or the panel's decisional rationale. In choosing the phrase, among other things, in their memorandum, the panel made conclusory declarations about the defendant's factually valid arguments. All of the legal standards that the appeals court panel cited in their memorandum were never effectuated. The legal standard and cases cited, which are required by law, were of no moment. Like Rule 23, they were only persuasive and not binding toward this particular individual or any other individual who has his or her case determined using Rule 23. It is unconstitutional. Employing the Rule 23 either-or standard, the panel stated that were we to attempt to address the defendant's claims, our conclusions would be no different. The panel used the defendant's ineffective counsel claim as an example. They cited the proper standard of review with cases cited. The proper standard was of no moment, as the panel relied solely on the either-or standard of Rule 23. The panel affirmed that having reviewed the transcripts of the lobby conference and the plea hearing, as well as the submissions from plea counsel, we encountered nothing. The defendant filed his appeal pro se after being told he did not have a right to counsel. He has no knowledge of what the appeals court panel is referring to in regards to submissions from plea counsel. Neither will anyone who will rely on Commonwealth v. Toppi for its persuasive value. Finally, the panel purported that plea counsel advocated forcefully for a lower sentence and endeavored to have the sentence attached to the lesser of the indictments. It was plea counsel who improperly cited the incorrect history category level initially, which the court then adopted and applied. It cannot be said that after improperly elevating the sentencing guidelines history category level, plea counsel was ever advocating for a lesser sentence. Indeed, counsel could have endeavored to have the sentence attached to the lesser of the indictments when she filed her motion to revise and revoke immediately following the plea hearing. Even a casual glance at the Massachusetts sentencing guidelines would verify the defendant's claims, and a review of the record would verify that counsel committed a fraud upon the court. Rule 23, formerly Rule 128, is unconstitutional and outdated. As computer databases became more accessible, parties began to cite Rule 128 decisions more frequently. Eventually, the appeals court changed the rule prohibiting the citation of unpublished decisions, holding in Chase v. Curran, 71 Mass. Appellate Court 258, 2008, that unpublished decisions after February 25, 2008 could be cited for their persuasive value, but not as binding precedent. Indeed, the Commonwealth cited such a case in their brief in regard to the defendant's appeal. These cases are being published on the court's website as well. However, the manner in which they are prepared and the cursory treatment of the issues remains the same. Rule 23 decisions contain only a brief statement of the underlying facts. They represent only a minority view of the court, as they have not been reviewed and approved by any judges except the 3 who decided the case. This leaves the door open to abuse of the rule, which occurred in this case. The facts, as stated in these opinions, may be so incomplete, as they are here, that they mislead the public about the basis for the decision, who will then misinterpret its scope and effect. In conclusion, the appeals court panel's use of Rule 23 was arbitrary and capricious. It was used to punish a citizen who petitioned the court for redress of grievances in violation of the First Amendment. It allowed the panel to A, rely on factors that Congress has not intended it to consider, B, fail to consider important aspects of the claims, C, offer an explanation for its decision that ran counter to the evidence presented, and D, offered an explanation so implausible that it could not be ascribed to any standards of law that the panel itself cited. This court should grant certiorari review to change this practice and maintain the integrity of the judicial system, and to prevent a miscarriage of justice. Respectfully submitted, William S. Toppi, Petitioner Pro Se, December 2nd, 2022. Now, I'm not a lawyer, so I did the best I could. The departure from accepted judicial norms in my case is evident, and I believe it qualifies as a compelling reason for the highest court to intervene. It underscores the gravity of the departure from accepted judicial proceedings in my case. The instances I presented where an appointed counsel used her own suppressed evidence against her client, and the judge who violated procedural rules through deception, points to a significant departure from the usual course of judicial proceedings. And it's concerning that despite the clear evidence and a genuine effort to address these violations, the Massachusetts judiciary has not provided due consideration and justice. In turning to the United States Supreme Court, I exercised my First Amendment right to seek redress for these constitutional violations, and I believe that such issues deserve the court's attention, aligning with the purpose of Rule 10. The undeniable evidence of fraud throughout my case emphasizes the need for the highest judicial authority to intervene, not only for my individual rights, but to uphold the foundational principles of the United States Constitution. My journey brings to light the challenges faced by ordinary citizens who are denied counsel on appeal, in seeking justice and holding those in power accountable, reinforcing the importance of constitutional safeguards. My decision to file a writ of certiorari under Rule 10 is rooted in the egregious departures from the accepted judicial norms. More importantly, it exposes the glaring fraud and treason that is carried out daily against our nation's most vulnerable citizens by a corrupt judiciary. In this case, it's evident that the procedural rules and ethical standards were breached. My counsel violated legal ethics by using her own suppressed evidence against me, using deception, a clear act of fraud upon the court. The judge, on the other hand, violated procedural rules and laws by engaging in ex parte communications with me, negotiating sentence terms outside of the accepted course of judicial proceedings, and he did so employing deception. In both instances, the Massachusetts judiciary should have taken decisive action. The Committee for Public Counsel Services should have thoroughly investigated and addressed these serious ethical violations. The trial judge should have recused himself or reported the violation. Instead, he denied my Rule 30 motion for a new trial without an evidentiary hearing. And the failure of the Massachusetts Appeals Court and Massachusetts Supreme Court to rectify these infractions led me to seek intervention from the United States Supreme Court. In conclusion, the judge in my case, David Ricciardone, and the counsel he specially appointed to represent me, Deborah DeWitt, violated several laws, including constitutional rights and federal statutes. They undeniably infringed upon my constitutional rights, such as the right to effective assistance of counsel, Sixth Amendment, and due process rights, Fifth Amendment. And as the judge engaged in deception during sentencing, it could be construed as a violation of the federal perjury statute. Additionally, their actions have broader implications, impacting the integrity of the legal system. Violations of ethical standards and procedural rules not only affect individual cases, but also erode public trust in the justice system. The duty of the judge and counsel is not only to the specific case, but to uphold the law and constitutional principles, ensuring justice for all. By violating these, they compromise the foundations of the legal system in our United States. However, before I go, let me say that, although I was disappointed in the denial of my writ of certiorari, and I'm well aware of the controversies surrounding our United States Supreme Court with its recent decisions and the issue of ethics, I'm not disappointed in the way that I was in the appeal process in the state of Massachusetts. The United States Supreme Court has discretion to deny a writ of certiorari for many reasons. The court receives thousands of petitions each year, but it can only review a limited number of cases. They might have concluded that the legal standard for granting a writ of certiorari, such as a circuit split or an important federal question, wasn't met in my case. And even if there are compelling reasons, the court may still choose not to hear a case. They could have looked at my case as primarily factual rather than legal. They typically focus on legal questions and may want to avoid reevaluating factual determinations made by a lower court. And they simply have to prioritize cases with broader implications or those that present novel legal questions. So while the denial of my writ of certiorari was disappointing, it doesn't mean that the court is justifying fraud in the same sense that the Massachusetts Appeals Court did. It might have been based on legal considerations, resource constraints, or a judgment that the case doesn't present issues of sufficient national importance or legal complexity to warrant United States Supreme Court review. However, they could have just as easily made a summary judgment in my favor without the need to explain anything, since the Commonwealth of Massachusetts waived any response to my petition. The point is, I can't live with what happened to me, and the thought that fraud continued and still continues today within the Massachusetts justice system is deeply concerning. I had to file my petition. I had to. The question now is, where do I go from here? Join me in the next episode of Constitutional Fraud, entitled Judicial Complaint. I'm your host, William Toppi, and our pursuit of justice begins with you.